Please stand and join us for a moment of silence and remain standing for the Pledge of Allegiance and salute to the Texas flag.
To the flag of the United States of America and to the republic for which it stands, one nation, under God, justice for all. I, the Texas flag, pledge allegiance to thee, Texas, one state, under God, one and indivisible.
Trustees present, starting on your left and my right, are Trustee Mackey, Trustee Flores, Trustee Mitchkay, Trustee Garcia. Our Superintendent of Schools, Dr. Michael Hinojosa, joins us, and I'm Justin Henry, Board President. Looking around the room, we don't have any elected or public officials present, so we will begin excuse me, with the discussion of board roles, laws, regulations, board policy, and board operation procedures, presented by Ms. Lynn Rossi Scott.
Ready for me? Let me see how this works. Can y'all hear me? Is this okay for me, or would you rather I be on the microphone? Okay. Okay, is that better? Is that better? Yeah. There we go. Okay. Good evening. I'm Lynn Rossi Scott, and I am an attorney with Brackett & Ellis in Fort Worth. I have been a school lawyer representing school districts since 1985. No, I don't want to know where you were in 1985. I was a lawyer. And it's been my pleasure to represent school districts over the course of that time. I've also brought with me Sarah Flournoy, Dr. Sarah Flournoy, who was previously in-house counsel to Irving ISD and has recently joined our firm. So she was very helpful to me in putting the materials together. I appreciate her being here. Over the course of that time, obviously, I've had a lot of involvement with school boards over that time. I've got lots of stories. I am going to incorporate some stories into this. I anticipate, I hope, let me say that this truly is a workshop, that you truly participate, that you ask questions, that you, okay, that you challenge me, that you talk to each other about the issues that we're going to be talking about. I will also say that I'm probably going to step on some toes. I do not know your politics. I intentionally don't know your politics. Because of that, I want to be able to just give you the factual information. I think it's important that you get the information, that then you'll be making some decisions. You've got some board operating procedures, for example, that need to be revised. You will be revising some local policies soon. And so you will be making some decisions about those things. I am going to use some scenarios in this. I will tell you that none of them are completely factually true. They are based on the truth, on experiences that I've had in the past. I will also tell you that none of them involve Dallas ISD, okay? They were all other school districts. And I do think that it is important to say that the things we're going to be talking about really are things that every school district struggles with, every school board struggles with. And so we're going to be talking about a lot of things. We're going to be talking, number one, on why being on a school board is so different than anything else you've ever done, what the constitutional restrictions are. Then we're going to go into your school district a little bit with a focus on the students, with the educational philosophy and goals, and the equity issues. But just to make sure we keep the big picture in mind as we talk. Then we're going to talk about board member authority, board member duties and responsibilities, and prohibited board member conduct. I anticipate next time we'll talk about evaluation, supervision of the superintendent, and the other personnel matters that you get involved in, purchasing, vendor relations, and then grievances and your involvement with grievances. And then finally, we'll wrap up with student records, public information, and the Open Meetings Act. For those of you who are lawyers, we have applied for continuing legal education for this. Yes, you'll get your year taken care of right here. That submission was made to the State Bar today, and including a half hour of ethics. So we'll let you know how that goes. But we wanted to take care of that for you. And we have submitted to the Attorney General the open meetings and open records and are waiting for their responses. I fully anticipate they will approve them. They've approved them in the past, the same outlines. So I fully anticipate that will happen. All right, so let's start with why this is so different than anything else you've done. And to do that, we have to go back to the 1700s, to the U.S. Constitution. The U.S. Constitution was written at a time when we all remembered King George, okay? We wanted to create a government. We wanted to be able to run the United States as the United States and create a government. Lots of people didn't want a government because King George just was a government and he caused all kinds of problems. And so what happened was no one would approve the Constitution. Okay? So in order to protect the citizens, they came up with the Bill of Rights, with the amendments to the Constitution. And they approved everything together. And what the Bill of Rights did is it gave the citizens power, and it limited the power of the government. Okay? It gave citizens free speech, free press, free assembly, the ability to petition the government for redress of grievances, free exercise of religion, protection from the establishment of a religion, no search and seizure without warrant, due process where you had to get notice in a hearing before we deprived you of any of your property, liberty, or your life, could not incriminate yourself in criminal cases, could not take your property unless we gave you money for it. You got a speedy trial, you got to confront your accuser, you got to have an attorney. And finally, the 10th Amendment that said if it's not delegated by the Constitution to the government, then that power rests with the people. Okay? So here's what's happened is all of you are very, very successful out in the community. You are business people. You are advocates. You are community volunteers. You have been exercising all of those rights that we all have as citizens out in the world. Okay? And everything else that you've done, whether you're operating in a business, whether you're operating in a community organization, whether you're operating in another nonprofit, you have exercised all of those First Amendment rights. When you walk in the door and sit at this table, you just gave up a whole bunch of those rights because now you are the government. Okay? You just switch sides. You are now the government, and your task is to protect the rights of everybody else. You have to protect the rights of the citizens. Okay? And that's a huge switch. That is a huge, you are now the man, okay? You are the folks who make the decisions, who operate this section of the government. But in doing so, you have to protect the rights of the people who come to speak in front of you, the employees who have contract rights, and you don't terminate those unless you go through due process of law. You have to follow search and seizure if you want to look in an employee's bags, if you want to search a student. You have to follow all of those rules, okay? You've now become the government. So your responsibility is to protect all of those citizens. So that's a huge change. What that also means then is there are now federal laws and then even state laws that come into play. So obviously we've got federal laws that protect free speech, free religion, search and seizure, due process, but we also have laws, federal laws now, that protect discrimination or retaliation on the basis of sex, requiring equal treatment on the basis of sex. Title VI that requires no discrimination, no retaliation on the basis of race, color, national origin. Title VII, that's also race, color, national origin, but it's specifically related to employment. The Age Discrimination Act, where you cannot discriminate against someone who's over 40. Family Medical Leave Act, so you have to allow employees to have up to 12 weeks unpaid leave. They can use paid leave if they have it, but family medical leave is unpaid. We have to protect individuals and make sure that we accommodate them if they have disabilities. We have the Family Educational Rights and Privacy Act, so we have to maintain the confidentiality of student records. There is a law called the GINA, it's Genetic Information Non-Discrimination Act. We have to protect If we have information related to a person's genetics, we have to protect that. That's federal. Then if you look at the state, we again have a state constitution that's very, very similar in many respects to the U.S. Constitution. Then we have a set of education laws, and you've seen that book. It's a huge book of education laws. We also have a set of government laws that contain the open meetings, open records, construction, those kinds of things. And we have a set of state criminal laws that also apply, a lot related to public servants and what public servants can and cannot do. So when you operate as a school board member, you are operating under a great deal of restrictions that you've never had to operate under before. And a great example of what's happened to very, very, very well-meaning folks are three. You see up here, Beaumont ISD, El Paso ISD, and you know what's going on with Houston ISD. And the thing I want to say about Houston ISD, even if you read the report, these are not bad board members. These are not bad people, okay? They are good people who thought things made sense, who thought that they were doing the right thing. They absolutely weren't, okay? They were violating all these laws we're going to be talking about over the next few days, but they weren't bad people, okay? And that's why it's important to do this kind of training, because what's intuitive to you of what you should be able to do, because you can do it in business and you can do it in your law firm and you can do it in your community organization, you cannot do as a public servant, as a school board member. And so that's why we do this. But Houston ISD, the report found that they violated the Open Meetings Act, that they influenced vendor contracts, steered contracts to certain people. They were not totally honest with the investigators, which never helps. They spent too much trying to govern the employees instead of letting the superintendent govern the employees, and that's his job. They acted outside of their authority and circumvented the superintendent when they did so, and that got them in a lot of trouble. They failed to follow contract procurement laws. They tended to ignore a few things. And there was a great deal of infighting, and I think the infighting is really what took them down completely, is the infighting between board members and between employees in the district and the board. The report also found that they interfered in day-to-day operations. They violated their own board policies. They manipulated procurement to avoid purchasing laws. You know, you get it under the limit and do a bunch of those and avoid purchasing laws, which is financial mismanagement. And then there was just financial mismanagement. So they had a number of issues, and it is important, I think, that we recognize that they were good people. They were good people doing what they thought was right. It just violated a lot of laws when they did it. And so that's why we're here, is to make sure that y'all understand what the laws are, because lots of things can happen. All right, so let's start talking about your own programs, because we said we're going to start with talking about your students. So first scenario, Anthony comes to the board with one goal in mind. He wants to dismantle the ESL programs, immerse those kids and make them speak English. Anything wrong with that? This is a board member, yes. This is a board member who wants to dismantle. Sorry, board member Anthony. Sorry, should have said that. Comes on the board with one goal in mind. Yep, he ran for the board to do this, to dismantle ESL so that those kids could be immersed and speak English. Any problem with that? He's entitled to his opinion. He is definitely entitled to his opinion. He absolutely can express his opinion. He is not entitled to tell the superintendent what to do about the ESL program. There are some board decisions that would be made there, and certainly, especially for your district, I think that would just not fly, given your own goals, the goals that you've set. So let's talk about those goals. Your educational philosophy is quality education for all, and that's what we're focused on, is enabling students to achieve their full potential now and in the future in all social, economic, and educational opportunities that they may have for the future. A general diffusion of knowledge, which comes from the Texas Constitution, is essential so that all of our students receive an education, and recognizing that families are important, that strong, dedicated, supportive families are important, which is a lot of the innovative programs you've done, especially in the last few years, to empower families, to get them more involved in their children's education. Your mission is educating all students for success, and your vision is to be a premier urban school district. I was doing a harassment investigation in one of my client school districts today and told him I was headed here, and he actually said to me, you know, I've always thought it was interesting that that their goal has been to be the premier urban school district, and I have to say they're getting there. They're making such progress in Dallas, and they're doing so many good things and so many innovative things. He said they're really somebody we look up to now. So I think that speaks a lot to the things that you've been doing, and a lot to the importance of goal setting and working towards those things. So your core values are trustworthiness, responsibility, respect, caring, citizenship, and fairness. And that is, and it's interesting, we did training for employees a few years ago on just, you know, how to behave kind of things. I did it with Letitia McGowan. And this was, I think, some of the things they're most proud of is when you're dealing with employees, when you can go back to these core values and say, this is what we expect of all of our employees. Makes it a lot easier when you're making decisions, when you're making personnel decisions. As far as the board and the superintendent, your board policies say that the board will declare their beliefs, and then the superintendent implements. And that is the differences. The board, as Mr. Flores said, the board declares their beliefs, and the superintendent implements. And we have to make sure that those things happen that way. The board tells the superintendent their expected outcomes, and then they hold him accountable for it. They hold him accountable for those outcomes. The superintendent then is responsible to align his work with all of his employees with that strategic blueprint that you, the school board, have put together. And for all students, that is to improve the quality of their education. Yes, sir.
As a practical matter, what are the ways that boards can hold superintendents accountable?
As a practical matter, number one is your evaluation. That is the most important thing that you do, is evaluate the superintendent. You may, I don't know how many times a year you do that. Twice a year? Once a year. Okay. That's probably not enough. And we'll talk about evaluation of the superintendent later, but yeah, he's not real happy with me. Okay, I've upset the first person. We'll see how quickly they all go down. Because here's what you want to do when you're evaluating someone. First, you want to tell them what you're going to evaluate them on, okay? Here's my goals for you. This is what I expect of you. And then you want to check in with him and see where he is with those goals. And that may be a midterm evaluation, that may be a midterm report, that may be monthly reports, depending on how you want to do that. And then when you get to the end of a year, you're doing a number of things. Number one, he's giving you a report of how he's accomplished the goals that you've set for him. Number two, you're telling him how you think he did on those goals. And then number three, you're setting new goals for the next year. Okay? So it really should be a continual process that you're going through when you're evaluating the superintendent. Obviously, you're also making contract decisions and salary decisions, and that can have an impact. You can, as a board, you can require certain reports. As a board, you can make those kinds of decisions, and then the superintendent will provide you those reports. And actually, your board policies do provide for that quite often, and your board operating procedures provide for that quite often. But it's what you don't want to do, and let's talk about that a little bit too, what you don't want to do is go around your superintendent. You know, you don't want to go to other folks and say, so how's he doing? You want to be communicating with your superintendent. You want to be letting him know of your expectations for him so that you can appropriately evaluate him, appropriately let him know where you expect him to go. Did you want to talk about anything else about that?
Well, no, I think that was helpful. I just, when you're holding somebody accountable for something, obviously the extreme situation is you can terminate the person.
Yes.
And then you've got, if it's wrongdoing that doesn't rise to the level of termination, you can do a letter of reprimand or a letter of concern. If it's not, a bad faith or something, you can, I guess, still do those kinds of letters.
Absolutely.
But I just wanted, we have some new board members here, just wanted people to know something beyond just the general, phrase, hold them accountable. Well, how are you going to hold them accountable?
That's a very good point. And that the best way to do that is to have that communication, whether it's in writing or whether it's orally. You do want to have that communication. Obviously, at contract time, you'll be making decisions on terminations, non-renewals for all of your employees. Typically, your superintendent, and I don't know how long Dr. Hinojosa's contract is, but I presume it's more than 1 year. 5 years? Do you have a 5-year contract? You do. Okay. And that is typical for a superintendent. And so that gives you an opportunity to have those regular conversations. I will tell you, my clients that start having concerns about a superintendent start meeting more often about it. Let's set some goals. We may have to change goals in the middle of the year because some things have happened, and let's meet more regularly so that we can give you input. Because the ultimate person who gets to make those changes is the superintendent, but he has to have from you adequate information in order to do so. So you want to make sure you're communicating it. Okay. All right. So the superintendent's responsibility is to make sure that all of our employees are here to improve the quality of education for all of our students, and to take action if they are not. Every employee is expected to believe that every student can succeed, because every student can succeed. That's just a truth. What you've also done is you've set student outcome goals. And I really like your student outcome goals. And I know you're involved in Lone Star governance also. And the thing I like about Lone Star governance is because it makes you focus on what I haven't seen school boards focus on in a long time, which is the academics, which is really why you're here, And so Lone Star governance has actually been very good at that. But your first outcome goal is increasing student achievement, focusing on Domain 1 subjects and third grade reading, because third grade reading is so critical to the rest of a child's education. And then your focus on college, career, and military-ready students. Also, increasing extracurricular participation for students, which is critical to keep students engaged in school and to keep them coming to school and to keep them active in school, is a great goal. The constraints that you're under is that you cannot have a low level of campus satisfaction. That becomes something for the superintendent to examine on the campuses, or his folks to help him with that. And that there should be no negative student experiences. We know that that's not always possible, but that is the goal. Your theory of action is managed instruction with earned empowerment, which is basically a whole child approach to student achievement. So you don't just look at a student's grades, you look at where are you coming from, what is your situation, where are your deficits, where are your strengths, how can I help you, what's your home life, what else? What other things are impacting your ability to learn? For your employees, you have a core instructional plan, you have training for them, and they are to follow the laws. That's the managed foundation. And then you get school performance ratings based on that whole child, and then your employees are empowered to be more flexible. When they achieve what they need to achieve, then they get more flexibility. So it's a great system for accomplishing great things on campus. You also have some more strategic covenants. Your strategic covenants, number one, is that you are a single district and you do provide equal opportunity. And you've added some besides what's in the law right now: race, national origin, ethnicity, gender, sexual orientation, religion, socioeconomic status, disability, gender identity, gender expression. So you have expanded beyond what the federal protections or the state protections are in who you want to make sure get equal opportunities. I think that's, you were one of the leaders in that, actually, around the state, and I think that's real important that you were. You also recognize that when you've got students who are falling behind, it is going to take more money and more resources to bring them up to speed. And so equity means that you may have to put more resources into certain students because they need it. You've also got a strategic covenant on staff diversity at all your levels, and you're holding your managers responsible for that. You have schools of choice, all kinds of schools of choice, whether they're the neighborhood school, magnet schools, Montessori's, Vanguards, learning centers, academies, project-based, early college, virtual charters. I will tell you, my favorite place in the whole world is your Barack Obama Academy. I love that place. I love going there. You've done some amazing things in some amazing places, and have every reason to be proud about that. Your students have an equal opportunity to attend those schools. The last time I visited the Barack Obama Academy, I was talking to young men who came from all over your district. I mean, literally all over. One took 2 buses to get to your campus every day, and that says a lot about that program. You also want the highest rigor and highest innovation for all of your students, and you have been putting in a lot of very, very innovative programs, so you're clearly working to that. Dual language, your ESL is one-way dual language instruction, and then your non-ESL is 2-way dual language. Facilities and construction efficiency, you are trying to avoid overcrowding, taking care of students' health and safety, equal opportunity to make sure that regardless of socioeconomic status or geography, that students have the appropriate facilities. That takes money and that takes time, and you're certainly working on that and focusing on that. And that your feeder patterns too reflect that diversity. Your partnerships with outside entities, that's one of your strategic covenants, is designed to decrease your educational costs. When there are resources within the community that you can use those so that you do have fewer costs. And then parental investment, where you are educating parents, you are preparing parents to prepare their children to come to school so that they are ready when they come to school. You're also growing your own leaders. Your apprenticeship and fellowship programs for your aspiring principals, your starting teachers, that you give them every opportunity to succeed, because we lose a lot of teachers in those first 3 years. It's just overwhelming, everything that they have to do. So you've focused on that so that you give them fewer other responsibilities so they can focus on being successful in the classroom. And then nationwide searches for your leaders so that you are making sure you get the very best. And then making sure your community volunteers are appreciated and used to augment your staff in a number of different ways in order to boost your student achievement. And then your early childhood programs, you've made a lot of great strides in that area, expanding your programs inside and outside the district. Your nutrition and health strategic covenant is to make sure that you are promoting an active lifestyle and that students' health needs are being satisfied. And then outside of school environment to provide quality after-school, weekend, summer programs for your students. All right, so now let's start talking about board member authority. Well, I'm sorry, one more thing. Let's talk about your racial, socioeconomic, and education equity. So Giuseppe makes his decisions on the board based on who's Italian. Time to represent the motherland. Obviously, that's going to happen and has happened in more than one district, but it kind of goes against what we say, because what we say is that we have racial equity and socioeconomic equity and educational equity. So yes, we want to help the folks who come from the motherland, but there are a lot of motherlands, and we want to help all of them, and we want to help all of them equitably. So we want to achieve and maintain racial equity, treat people with fairness, provide them additional resources when they need additional resources in order to be successful, provide a barrier-free environment for them, don't put things in their way that prevent them from being successful, and then make sure our students then are equipped to deal with the diverse world that they are going into. You've created a racial equity office to address a lot of those issues, and I think when you put money behind it and you start focusing on it, then you'll see a lot of success, which is what you've done. So that's excellent. All right, so let's start talking about board member authority. Beth, the board president, has a private email account. She blind copies all board members about a situation, gets consensus, and then proceeds to put the issue on the agenda now that she knows she's got the votes she needs. Got any problem with that? Yep, exactly. Cannot do that for a lot of reasons. Number one, because now The definition of deliberation has been changed in the Open Meetings Act, and we're going to talk about this several times, but it now includes written deliberations, written discussions. And so because of that, an email can be a meeting, okay? And if you haven't posted that email as a meeting, then you've got a violation of the Open Meetings Act. Number two, you can't have a walking quorum. You cannot find out what everybody wants to do and then come to the board and do it, or take action another way. You've got to come to the board and then hear what everybody has to say. That's what board meetings are for. And I think that is one of the many things that's so difficult for board members, because board member service is very different than anything else you've done. Number one, they're nonpartisan elections, okay? You didn't run as a Republican or a Democrat. You ran as someone who wanted to help take care of children in the Dallas ISD. You are subject to the Open Meetings Act. You have no power except as a body corporate. That's the only time you have any power. You are an individual. But you have to do that in a meeting, and that meeting has to be called and the agenda has to be posted so that the public knows what those things are. Public Information Act. Your communications are subject to the Public Information Act. So if you are on your phone sending a text message and it's about public business, that text message is subject to the Public Information Act, which, you know, let's face it, most of our text messages, we presume they are private. We have confidentiality laws. We must maintain the confidentiality of certain information. That can be employee information. That can be, definitely is, student records. There's a lot, and we're going to talk about those. And then you have statutory and constitutional authority and limitations. We already talked about that. So yes, sir. Uh-huh. You can't. Well, you have to look like you're listening to them. How's that? Does that work? Okay. has to be in a meeting. Well, you know, and the interesting thing is your own operating procedures are really interesting about that. And I think it's a great idea. I think your board operating procedures, you got to change some things because the law's kind of moved on from your board operating procedures. But one of the things it does is say, if you have a disagreement on the board, you don't address it to that board member, you address it to the board president. You state your disagreement to the board president monitors, you know, the discussions that are going on, so that it does not become personal, so that it really truly is, I'm expressing my opinion. My opinion may disagree with your opinion, and that's fine. There is no reason why our opinions have to be the same. But it does not become personal then when you do that. So I think you've got some things in your board operating procedures that are really good that kind of try to help you through some of those things. Okay, it's in there. It's in there. And now you can rely on it because it's in there. I do think it's a good idea. I think, you know, I do think some of the most tense situations I have been in at a board meeting is when two board members got in it together. And that's always counterproductive. Whereas if you can just state your opinion, you're stating it to the board president, you're not making it personal, I think you can accomplish a lot more. Let me say that. Okay, so the other things that are different about school boards is you are not managing. You are not managers. You oversee the management, and the management is the superintendent. And so you are overseeing what he does, but you are not the manager. And that's very hard. You know, we're all used to being on other boards. I'm on a theater board, a community theater board, and when they say, okay, this is what we need, what they mean is we need you all board members to go do this. You know, you're acting, you are taking care of things, you are involved in things. And that's not what you do as a school board member because you're the government. So you're not going in there and managing things. I mean, as a board member, I've terminated employees on this community board because I'm the lawyer and we always get those jobs, right? And but when you're on a school board, it doesn't work that way. When you're on a school board, you you turn to the manager to do those things. The other difference is you're a taxing authority. You know, we don't have taxes for nonprofits and other organizations. So you also have a fiduciary duty, and you have a huge budget. You just have a massive budget with so many different parts to it. But you have a fiduciary duty to the district that overrides all of the things that you do within the district. The other thing you have to deal with is politics. And I acknowledge that, much more so than you would have to deal with in any other nonprofit that you worked with, any other organization or any other business. You've got to deal with politics, and politics are never easy. The other thing you have is the media, because the media always wants to second guess what you've done. They're really only, for the most part, interested when you mess up, because that's what makes news, as opposed to when you do things right. I actually had a situation where I was talking to a reporter. She had asked for a bunch of documents, and I sent them to her, and I followed up with her and said, I'm just checking on this, sent you all these documents, want to see what you want to do. And she said, oh yeah, we're not going to print any kind of story on it. It's like, why not? We did great. We did a great job on this issue. Why do you not want to report on it? She said, because you did everything right. There's nothing to report. You know, what are we going to do with that? I was like, you know, you just can't catch a break. So, but that is the kinds of conversations that you can have with the media. And so it is different. That is one of the reasons why your board operating procedures says that your board president is the one who's going to speak to the media. Because can you imagine 9 different people making their own statements, all of whom are going to say something differently? That's tough. That's very, very tough. And that it makes it harder for you to appear as a solid, cohesive district when you've got that going on. And that's why you have 1 spokesperson rather than 9 spokespeople. The other thing that's different about a school board is a school district is almost always the largest employer in a community, and that's always true in our small communities. But they're very often the largest employer. Everybody is an expert on your job. They can know exactly how to tell you to do it, and they're an expert because they went to school once, and so they know all about education, and they haven't been through the training. I think the hardest thing for you is that people who are not within the district do not understand your role. They do not understand your limitations. They think, oh, I know a school board member, I can make anything happen, right? Because you can make anything happen. And the reality is you cannot fulfill those expectations. You are 1 person out of 9. You may or may not be able to persuade the other 8 to do something. And so to me, what I tell board members is that you start conversations with members of the public with, I have so little authority. I am 1 out of 9, okay? That is all I am. I cannot do anything on my own. You let them know what little ability you have to make a change by yourself. You know, if the school board is going to look at something, you have your opinion, absolutely, but you don't control the other 9. So I think it is important that people understand what to expect of you, as opposed to they call you and they complain and you say, I'll take care of it. And they truly think you are going to take care of it. And they truly think you are going to take care of it their way. Okay? And that just doesn't happen, and that just can't happen that way. You get those kind of complaints, you send them to the superintendent sends them to whoever can take care of it, and it'll be addressed, but it may not be addressed the way that person wants. Then they come back to you and they're disappointed. Well, that is nothing that you can control. You absolutely cannot control that. So I think it's best to let people know up front. I think that's easier. All right, so when you're looking at decision makers within the district, you're starting with your board of trustees. You set policy. You establish all of the policies. The policies are the number 1 way that you set expectations. So back to your question earlier, how do we set expectations for the superintendent and monitor that? The number 1 way is your board policies. If you don't like the direction that what the superintendent is supposed to be doing is doing what you've established in your board policies. If you don't like the direction he's going, but it complies with that board policy, you have the ability to change that board policy. Okay? So that is the very first thing that you are responsible for. Then the superintendent, who is the manager and the educational leader of the district, and he sets up programs in place to hire and fire employees, to make sure the facilities are taken care of, them, to make sure that students are educated, everything else. He establishes his programs and his people in place to make sure that those things happen. The other decision makers, and I hesitate to call them decision makers, but your policy kind of says that they are, but they're really contributing information. Your district level committees and your campus level committees provide a great deal of information and input to your campus principals and then to your superintendent and his administrative staff. All right, so when you look at board authority, number one, the legislature decides what your powers and duties are. You, according to law, govern and oversee the management. You don't manage, you govern and oversee the management. It also says that any educational functions that are not delegated to the Texas Education Agency or the State Board for Educator Certification or the State Board of Education are then reserved to the school districts. Yes, sir.
You may have this in another slide, but I think, especially, again, for newer board members, examples of what's governance and what's management would be really helpful.
Okay, great idea.
Okay? You know, like a lot of examples. Like you don't hire the football coach. You don't have an input on that. You don't fire teachers and things like that. Yeah, we don't.
You don't. I mean, I've actually had school boards who insisted that they be in on those interviews, and I tell them absolutely not. Get away from it.
Okay, my point is
yes.
that there's the
Yes. Okay. All right.
management
so let's
and
talk
governance, but they're abstract concepts to,
Yes.
to
All
new
right.
trustees.
Okay. So let's talk about all of those areas. Let's start with some of the easier ones. Let's talk about facilities. Okay. Facilities. You will decide whether or not bond issues are going to be called for election. Okay. You have very, very serious restrictions on you when you're in the middle of a bond election on what you can do. You cannot spend public money, basically, to advocate for it at all. All you can provide is factual information. And then when it comes to the facilities themselves and how they're going to be constructed, typically depends on your board and what you have made decisions on, but typically you would only get big picture information. You would never, for instance, look at plans and specs. I will tell you this, I have a board that did want to do that. They wanted to look at plans and specs. Well, they can't read plans and specs. I mean, those things are murder to read. But what they did do is they sat down and they said, okay, we want to know big picture. We want to know big picture what's in this building. And one of the things they found out was there was going to be a bowling alley in that building. And they said, we don't want a bowling alley in that building. Why is that there? And the superintendent, it turned out, didn't know there was going to be a bowling alley in there because the architect sat down with the teachers and said, what do you want here? And they wanted a bowling alley, and so he put it in. And so what they did was, yeah, it was a little scary. And so what they did was they went back because I had a big discussion with them about what's your role versus what's the superintendent's role. And we put a process in place where the superintendent got to find out what the big picture things are. And then the superintendent presented to the board, this is what I want the big picture. This is what I want the big picture things to be. And he didn't like to bowl, so we didn't end up with a bowling alley. We did end up with a swimming pool, but that's a whole different story. Yeah, there you go. There you go. We also ended up with a roof that didn't meet, but that was a whole other story too. All right, so your facilities, we will tell your superintendent, we want this level of equity, we want this level of cleanliness, we want this level of safety, okay? And then it's up to your superintendent to implement. So you really are looking at the big picture things. Personnel. Let's talk about personnel. Your responsibility in personnel is to hire personnel based on the superintendent's recommendation. You don't get to go investigate these people before they are presented to you. You don't get to do anything except accept or reject who he recommends to you. If you reject, you don't get to tell him who to hire. He we'll come back with another recommendation. And then you will look at that. Yes, sir.
The superintendent has a contract where the superintendent has hiring authority and does not have to go to the board.
Oh, okay. For
To-
all contract
approvals,
employees?
yes.
Okay, okay. All right, that's great. Except football coaches, of course, because they're the most important, right? Okay. And the brick on the outside of the building. Oh, there's so many inside stories here. I can tell. Yeah, I did have a board do that. I did have a board do that, and I always get bothered by that. You know, when the architects, I don't know if your architects ever do this, but they bring these pretty little things with all the different colors and everything. Well, as soon as you start doing that, there's going to be a board member who doesn't like green, you know, and wants all the green out of that, or another board member who doesn't like blue, or mauve is just not the color that I want in my building, and mauve, it's pink, pinky. Yeah, it's like a purpley pink. Yeah.
All
I
right,
don't
Ms.
know what
Lynn,
puce
can we-
is. What's
can we-
puce?
Can we keep going, please? Thank you.
All right. So let's talk about. Okay, we did employees. We did facilities. All right. So let's talk about complaints. Okay, grievances and complaints. So you get phone calls. I'm sure you all get phone calls of people complaining. The landscaping is not done well on this campus. I actually had a board member call me one time and said the bushes were uneven, and I told the board member, "So what? You know, that's not your job. You don't take care of that. Your responsibility when you get complaints is to let the superintendent know. You don't get in the middle of it. You don't investigate it. You don't promise them any kind of an outcome. You let the superintendent know so the superintendent can let the proper people know to take care of any complaints and to address any issues." So what other areas can you think of that we need to talk about specifically? The thing about grievances is they're going to come to you, and so you really want to stay out of those. So if you get an employee who complains and says, "I'm grieving about this, I really want to talk to you about this," and you start talking to them or you start participating with them. I've had board members attend a level 1 grievance or a level 2 grievance. And I've told that board member, when it gets to level 3, you cannot be in the room. You cannot be there because you have eliminated yourself by being in the level 1. You can no longer even claim that you are being objective. So it is important that when you get those kind of complaints that you let folks know, look, I've got to hear this at level 3. And so I've got to be able to hear it objectively at that time, so I need to stay out of it now. So those kinds of things. Okay. All right. So, yes, sir.
So if a board member is coordinating with somebody who has a grievance against the district, then that person can't sit in the grievance hearing at the end.
That's my opinion. That is absolutely my opinion. Is once you start inserting yourself in that process and you start taking sides at level 1, 2, 3, then I think you've set yourself up that you cannot be an objective, because your responsibility is to be an objective decision maker, to look at everything for the first time that is presented to you from the grievance, ignoring everything else, everything that is outside. And so once you start inserting yourself into that process and being at a hearing or advising someone, I've had board members do that, advise someone on how to present a grievance, doing those kinds of things, then you've inserted yourself in it and you're really no longer objective. And the most difficult conversations I've had with board members is who have done that and then they've sat there at level 3 and I've had to ask them to leave. I mean, that's very, very difficult. But I do think, I mean, you just can't argue your objective at that point. How can you say you're objective when I've been helping this person get in front of this board? I just think that's very difficult. Did you have a question? Okay. All right, so your only authority is acting as a corporate body. That when the board votes, the board can only delegate when you're allowed by law. So what the education code says in a lot of places is that the board shall do this. When it says that, only the board can do it. When it says the board shall do this or can delegate to the superintendent, then you can delegate to the superintendent. For instance, contracts, you can delegate that to the superintendent. There are a lot of places in the statute where it says the district shall. Okay? When it says the district shall, then the board could do it, or the board can just allow the superintendent to do it. Most of the time when it says the district shall, that is the superintendent who would take care of that responsibility. The Open Meetings Act applies. So you cannot have conversations in a quorum other places and be transacting business. You cannot have a walking quorum. We're going to talk more about that. Your policies say that the way you get agenda items is that the superintendent proposes the agenda and the board president approves it, that any of your board members may submit agenda items 17 days prior, and that any 3 board members can require that something be on an agenda. You also have to give 72-hour notice of all agenda items. We did in this last legislative session get some changes to the Open Meetings Act in this area. And I'm going to be talking a little bit about open meetings today and then a whole lot at the end, because you really can't talk about what you do without talking about open meetings. So I'm afraid I'm going to do it twice. It used to be that you could give 2-hour notice for something that would be on the agenda that's an emergency item. Now you can do a 1-hour notice. You post it the same way on your website to the media, out in front of the building, those kinds of things. And it's only for emergencies, which are imminent threats to public health and safety or reasonably unforeseeable emergencies. And then they listed what those are now, which they had not done in the past. So they're natural disasters, power transportation failures, epidemics, riots, enemy attack, relocation of residents in disaster areas. When we got Hurricane Harvey, we came up with a whole lot of issues. And so a lot of what the legislature did this time is to try to fix the things that we realized were problems as a result of Hurricane Harvey. And this is one of those things. Because there's a lot of things that the boards had to do very quickly, not hold school, allow buildings to be used as shelters, those kinds of things. And so there's a lot of recognition that we've got to give some help in that area. So they did that in this last legislative session. So the definition of a meeting is when a quorum of board is present and topics that are within the jurisdiction of the board are discussed. So if you guys want to sit around, 5 of you, and talk about President Trump, you can do that all you want, okay? Because believe it or not, he doesn't have a whole lot of impact on what you do here. But if you want to talk about whether or not you're going to close a school, you cannot do that unless you've posted that on the agenda. So it has to be topics that are related to what's within your jurisdiction is what the law says now. That does include information sessions when all you're doing is listening to someone, but all meeting topics must be on the agenda. It does not include your social events, your conventions, your workshops, and press conferences where you go to the TASB convention or an SBA convention or something like that. It does not include that. Deliberation, the definition was changed in this last legislative session. Basically is an agreement with the Attorney General on an Attorney General interpretation. Now deliberation means a written or verbal exchange between a quorum of the board or between a quorum of the board and another person on any issue that's within your jurisdiction. So the or written was added, and the on an issue within the board's jurisdiction was added in this last legislative session. Really designed to target what we're trying to target is because of the proliferation of electronic communications, we've had a lot of folks do a lot of things that were outside the Open Meetings Act, and to try to curb that and to make it clear that the things you cannot talk about are the things that are within your jurisdiction. So one of the most dangerous things for you is email. Text messages, group text messages are very, very dangerous. So you want to be very, very careful about that, especially now as of September 1 when this new statute was in place. Okay, during board meeting breaks, the men meet in the restroom and discuss the agenda items coming up. Block votes are important as they show solidarity. Anybody have a problem with that?
I don't know, it's just creepy to be
It
in the
is
bathroom
creepy.
talking
It is
about
creepy.
board
And I
issues.
used it because there's
Sorry,
actually,
just-
there's actually a court case on this where Commissioner's Court Commissioners Court was meeting as a group of three, and they had a break, and the three men went into the restroom and discussed the case that they were dealing with, and came back out and got sued for it. And the court said, absolutely, that is a violation of the Open Meetings Act, that you would take a break and then continue to discuss.
But there were an open bathroom.
There was an open bathroom? No, not the same thing.
Not the same.
No, women are not allowed in there, so there's no
Oh,
equity
good
whatsoever in that.
There's
in that
not
communication.
enough women on this board, so we couldn't have a walking quorum if we wanted one.
I'm sorry?
There's too many men on the board, so we need more women if we wanted to have a walking quorum and get in trouble.
Good answer. All right. All right, so open meetings, all voting has to occur in open session. You cannot take straw votes in closed session. You can express your opinions in closed session all you want, but you cannot say, okay, so it's going to be 8-1, and let's come on out, or it's going to be 7-2, and let's come on out and vote 9-0. Okay? That is not allowed. Certainly, you are free to express your opinions in closed session, but you cannot vote in closed session. One of my school boards got in trouble with that one time. They came out, I was not there, thank goodness, because I would have had a heart attack, but they came out of closed session and said, we just voted back there to do such and such. And I found out about it the next day and did a lot of scrambling, and we fixed it. They went back and had another meeting. So, yes, sir.
Okay, so let me give you an example. Selling property. Can't vote on it in closed session. You can go, can you do this? Ben, he says sell. Edwin, don't sell. And you go around and all 9 trustees express their opinion. Is that a vote?
Okay, there's a big difference. Okay, all right, sorry. There's a big difference between, well, there's not a big difference. There's a tiny difference between a straw vote and what we're talking about. As the board president, you can make sure that all of your board members have expressed their opinions. And everybody has the ability to count, okay? Where we see boards really get in trouble is when, for instance, they go around the room and it's going to be if it's a 7-member board, a 4-3 vote, okay? And they come out in open session and they vote 7-0. So that we took a straw vote, we know how this is going to go, we're going to come out and show solidarity. Okay, that is absolutely prohibited. So where the fine line is, you are allowed to express your opinion, you are allowed to not express your opinion in closed session, okay? And the board president is allowed to make sure that people have the opportunity to express, I gotta get rid of that, have the opportunity to express their opinion. But no, you cannot do a straw vote. You cannot do a straw vote. So I realize that is a very fine line that hardly even makes sense, but that is the line. I personally get uncomfortable when the board president says, okay, I want to hear from everybody, okay? Because then we've got everybody counting. What is the vote going to be? I am more comfortable with the board president saying, anyone who wants to express an opinion, I want to make sure that you're heard. Has everybody had that opportunity, to tell us your thoughts? Rather than, I'm very uncomfortable if I ever hear of a board going around the room, Ben, what's yours? Edwin, what's yours? Dan, what's your opinion? That makes me uncomfortable. Okay. All right. All of your discussions are supposed to be in open session unless an exception applies. We do have a new statute about a walking quorum because previously the law said that you cannot meet in numbers less than a quorum to avoid the Open Meetings Act. And the Texas Supreme Court said that was too vague and therefore that statute was unconstitutional. And I will tell you that when that happened, we struggled in our office, are we going to let our board members know? Because we send out constant contact newsletters, those kinds of things to our clients. And we decided not to say anything to our boards because we didn't want to give them that opportunity to start doing walking quorums during that, knowing the legislature was going to come back around and fix it. And so they did. They made a very specific definition now for you. You cannot knowingly engage in at least one communication in a series of communications outside of a meeting where the series of communications involves a quorum, and you knew that the series of communications was going to result in deliberation by a quorum.
So if you don't know,
If you don't know, if you think you are just having a conversation with one person, and that's all you know, you are not criminally liable. Now, the person who is having the conversation with you, hold on. I didn't absolve both of you. Hold on. So, but the person who's having the conversation with you, who then chooses to call every other board member, is criminally liable. Okay? So it's you have to have, because in any criminal law, there has to be intent. You have to either be reckless or you have to have some kind of intent to commit a violation, okay? And the Texas Supreme Court said that what we had in the statute was too vague for that. So now, for instance, if a board member calls me, and it's happened, and he said, okay, I called every board member, and here's what here's what's going to happen at the board meeting. And I have always stopped them and said, okay, let's not ever, ever, ever do that again. But now I think the law is much more specific about that, is to try to differentiate between those who truly are innocent and don't know that there's going to be a series of communications, and those who do know. So if you have someone who calls you and says, look, I've got 3 votes. Are you going to be my number 4? That's when you know I'm not having this conversation.
but you don't know if they have the 3 votes.
Huh?
But
Well,
don't know
you
if they have
know,
the
you
3
know
votes.
they're having these conversations, okay, and you're next in line. You
Yeah, but I
don't
didn't
have that kind
know.
of conversation.
What if the person's a pathological liar? And you're used to them not telling you the truth. So you can be reckless and negligent, but as long as you don't know. Sorry.
I'm going to go out on a limb and say you don't have any pathological liars on your board, but, you know, I
Not
could be
right
wrong.
now.
Okay, well, there you go. There you go. No, that is what it comes down to. So if you are an innocent person in that, you're just having a conversation with a person, then there's no criminal liability. But if you know that that person is having other conversations, and the person who is having the other conversations, there is criminal liability. That's the concept now. We'll see what the courts do with that one. But that is the concept. All right, so what can you talk about in closed session? Well, personnel matters, whether it's employment, assignment, evaluations, reassignments, duties, discipline, dismissal, complaints. All of that goes into closed session, except that the subject matter of a complaint can request that the complaint be heard in open session. So if you have a grievance, for instance, and the person who is the subject of that complaint can ask that that grievance be heard in open session. So another personnel exception, and it's employee-to-employee complaints, when an employee complains about another employee. And in that one, it says that the employee who is being complained about can request open session, not the employee who is making the complaint, but the employee who is being complained about can say, I want it in open session. In addition, student discipline. We don't do student discipline matters in public unless the parent insists. And I actually just did one of those in public very recently where the parent insisted that it be in public. But 9.9 times out of 10, that does not happen. Anytime we are talking about personally identifiable student information, again, we go into closed session to discuss that. Parents, again, can request that that be done in open session. When we are talking about real estate, especially if talking about it in open session would harm your bargaining power, or someone doesn't realize, because let's face it, when it's the district buying property, all of a sudden the price is going to go up. Okay, that just happens. And so you do try to keep that kind of information confidential as absolutely long as you can to avoid that issue. And that's why you can talk about those things in closed session, because people tend to see, a big checkbook and think they can get in it. Legal advice and litigation, it is critical. Yes, sir.
Sorry, back to the real estate.
Uh-huh.
So you talked about the consequences of walking quorums, et cetera, and the criminal implications. Can you describe what happens if I'm in closed session? I'm in closed session. We discuss something, and I go home and talk about it with community member A.
Okay. Okay, it depends. That is not a specific criminal violation. It is absolutely a violation of your fiduciary duty. Okay? And that's really where it comes in more. The closed meeting agenda itself is confidential, okay? So you have a written agenda for your closed session meetings, or a tape recording. I'm assuming you do written agendas for your closed meetings. That is confidential by law. If you disclose that, it is a criminal violation. If you talk about the things that are discussed in closed session, then you are risking the district in a lot of ways. It is not specifically a criminal violation, but you are putting the district at risk. So for instance, real estate. You know, you tell somebody, oh, I hear they're looking at this property. All of a sudden that property is either not going to be available, it's going to be snapped up by somebody else so that you'll pay a higher price for it, or the price will go up. You have a fiduciary duty to the district to not talk about those things. Personnel matters, confidential matters. Any confidential matters, there are other statutes that would also require you to keep those confidential. Legal advice could be just terribly, terribly damaging to the district if you go out and talk about that, especially if you're talking about litigation. And I've definitely had board members who did that and were very harmful to litigation. Actually messed up a settlement one time because they went out and talked and that information got back to the other party.
Does it waive attorney-client privilege?
It was attorney-client privilege and they violated it. And the thing about attorney-client privilege is you as an individual cannot disclose that information. You have no ability to disclose it. The only way that attorney-client privilege can be waived is when the board says that attorney-client privilege is waived. So it requires a vote of the board to waive attorney-client privilege. I have had situations where I have given a written opinion that is attorney-client privilege to my client, and my client has put it on the board agenda to disclose it.
I mean, waive in the sense, if I talk to someone else, is it no longer confidential? If there's something I hear in closed session that's a legal opinion or a legal issue, and I tell someone in the public, is it no longer confidential?
Yes. Yeah. You're risking not being able to keep it confidential. Yes. Exactly.
Yes, okay.
Exactly. Because you've now disclosed it. Part of the determination of whether or not it's attorney-client privilege is whether or not you've kept that information confidential. So you go out there and you start talking about it, and you've destroyed it. Exactly. So it is critical that the advice that you get from your legal counsel, any litigation discussions, anything like that you're having with legal counsel, and not just on litigation, but on any matters, whether it's the matters I've come and talked to the board about in the past, or personnel matters, those kinds of things. It is absolutely critical that those things not be discussed. And, you know, the hardest thing is pillow talk. You go home and your spouse wants to know what's going on. And my husband and I had this deal for years. He's a stockbroker. I'm a lawyer. We just don't talk about what we do. It was a great deal. He's retired now, and he tells me everything. And I'm struggling with how to deal with that because I went for years not hearing all these things. And so absolutely, you feel like you can trust that person more than you trust anybody in your whole world, but you're still violating the confidence, and you're still risking the district. So it is critically important that people understand that you just don't talk about those things. There are criminal penalties if you improperly close a meeting when you did not have proper authority to do so, if you deliberate in secret about something, if you don't have the certified agenda that we talked about. Those are criminal violations. They can also bring an injunction against you or mandamus against you to force you to do some things. We do have a new statute that says that the public can speak on agenda items before or during consideration of that agenda item. That we as a board can establish reasonable rules to limit how much time a person is allotted. But if we do not have simultaneous translation equipment available, then we have to allow the people who need a translator to have twice as much time, because we want to make sure that they have an equal opportunity to present their information to the board. The new statute also says that the board cannot prohibit criticism of the public body, of the board, or any of the board's acts, omissions, policies, procedures, programs, or services. And that is a new statute. I will tell you that as a group of school lawyers, this thing is not well written at all, and there are a million questions that we have about it and a million interpretations that we have about it. And, you know, I'm sure that the Attorney General at some point will rule on it. I expect at some point we'll have some court cases on it. But until then, what we're most part trying to do is to make sure that we, in good faith, you've already had an open forum for a very long time. One of the things this was designed for was we had a lot of boards who would put their open forum at the end of the meeting. So the public did not have any opportunity to discuss anything until after the board had already taken action on everything. And the testimony that was in front of the legislature was, it's too late then. The board's already taken action. I want to be able to talk about these things before the board takes action. And so that was one of the reasons for it. Of course, they were concerned about criticism of the public body. The interesting thing is it does not say criticism of employees, okay? It just says criticism of the public body. I'm interpreting that the way it's written, that it's criticism of the board, that we have to allow people to criticize the board. I will wait and see what the interpretations come down, but I'm interpreting the statute assuming that they used the words they used intentionally. And I will just tell you that my interpretation of the word consideration is the public can speak on agenda items before or during consideration of that item. They could have used the word deliberation. And remember, deliberation is just talking about something, is orally or written, is just talking about it. They didn't. They chose to use the word consideration. Well, if you read agendas, very often the way agendas are written is consider action on this, consider approval of this contract, consider this, action on the student code of conduct. Consider tends to be a word that denotes action, okay? Rather than saying approve, disapprove, reject, postpone, all the possible things, you use the word consider. And so I'm interpreting that word as being when there's action items on the agenda, then we will have an open forum. And when there are no action items on the agenda, we will not have an open forum. That is the way I am interpreting it right now, recognizing the Attorney General may turn around and say that I, am wrong, because he does like things to be in the open. But to my mind, if they wanted to say deliberation, they would have said deliberation, and they didn't. Yes, sir.
Okay, so undoubtedly you've seen that the morning news column where the author basically stated that the new law allows the public to come in and speak on immediately before each agenda item as it comes up. So somebody can speak, according to this interpretation in this article, the board can do agenda items 1 and get that done, and then anybody wants to speak on agenda item 2 can come and speak on that. And once agenda item 2 is taken care of, then agenda item 3 comes up, and there's a public forum before agenda item 3 that is required under this interpretation. Is that a correct interpretation of the law?
No, it's just not. If he wanted to write it that way, he should have written it that way, but he didn't.
Who's he?
I don't know who he is. I don't know who the author is.
If he wanted to write it that way, he
The
could.
legislature.
The author of the
Okay,
legislation.
thank you.
Okay, let me say. The way it is written, it certainly allows for what a lot of my boards do now, is they have an open forum for agenda items at the beginning of the meeting and an open forum for non-agenda items at the end of the meeting. And the way I read the statute, it allows them to continue that so that you can get up and speak to a number of agenda items if you choose to do so. The issue I think there is if you want to speak to a number of agenda items, we may have to allow you the 2 minutes, 3 minutes for each of those agenda items. But it does not have to be immediately prior to the board's consideration of that agenda item. Okay? I do think the question is how much time we give you. That one I think is still an open question. I think that one's a little more difficult to answer. But no, the statute is not written that before each agenda item, before each action item, that there is a spot for open forum. It's just not written that way.
Okay, thank you.
Mm-hmm.
And you
Yes, sir.
mentioned the way the law uses address the public body. So again, that was another part of that, is like you can call people by name that are on the board, et cetera, from that. That is not your interpretation of this as a public body addressing the board, and that's what our current policy is.
Yeah, I mean, the statute says that we cannot prohibit criticism of the body, of the governmental body, is what it says. We have typically not allowed people to talk about specific individuals in public. We've taken that into closed session to listen to them, as opposed to in public. You're still listening to them, but this requires that it be done in open meetings, in public. If you read it very, very closely, then I think you're right, that if you're going to get up and talk, you're going to talk about the public body under that one, as opposed to an individual person. Yes, sir.
So if our instructions say, you can address the body as a whole, but you can't name individual trustees or the superintendent, then that's okay.
Do I think that's okay? Yes, I do. I think it's a very conservative interpretation of the law, but I do not think it violates. I don't think it violates the language of the law. This is not a well-written law. I mean, Ramona will tell you it is not a well-written law.
So,
the reasonable limitations that school districts can place on public forums?
Sure. Ramona asked me to talk about the reasonable limitations you can place on them. We did have a meeting at TASB, a number of school lawyers, to sit around and just talk through this statute, because there are so many issues, and that is one of them, is what is a reasonable limitation. And I will tell you that among the school lawyers in the room, and there was maybe 20 of us, that what is a reasonable limitation ranged from 30 seconds to 3 minutes. I was kind of surprised by the 30 seconds, but on the other hand, I can see that. When you're talking about a large public body who could have a large number of people who are interested, you can say a lot in 30 seconds. You really can. And so listening to everybody, I think you can establish a rule that typically this is what we're going to do. However, if we have a whole lot of people here who want to speak, then, because what it doesn't allow us to do is cut it off. It's say, look, we're gonna give it a half hour, and then if you haven't had the opportunity to speak, you don't get to speak. Okay? So you may have to set it up so where you do some on the fly. Typically you would get a minute, but because we have so many people, we're going to limit everyone tonight to 30 seconds, so that we can hear from everybody. We are going to be learning along with you all on this. What happens in a very, very small school district is very different than what happens in a very, very large school district on some of these issues. And so it's a new law with a new world. I have heard some of the craziest interpretations of this law ever. I've listened to media people who said that means I get up and lambast every single board member individually about anything I don't like about that person. And that's just not the way it reads. It's just not the way it reads at all. So I think that I think we're going to do some things and try some things, and we may have to change some things as we go along, as we get interpretations of this law. But it's very poorly written, and it's left a whole lot more questions than it's left answers. But I do think that we do have the ability to, well, I know we have the ability to limit the amount of time. How we do that is, there's all different kinds of ways to do that. Yes, sir.
So does that have to be written in a policy, or is that something that the board could decide on the spot? I mean, what would you recommend?
Yeah, my preference is that it is, you can do it as a regulation. It doesn't have to be a local policy. It can be a local policy. It can be in your board operating procedures. It can be just a card. I've got boards that do that. They didn't adopt it as a local policy, but they adopted a statement that will be read, and they've all agreed on what that statement will be. I don't think it's necessary. Is y'all's in a local? Is it? Okay.
So let me
Okay.
just, so what if we said, you know, you get 2 minutes up to 30 speakers, but if it's over 30 speakers, then you get a minute, and if it's over 60 speakers, you each get 30 seconds.
I think
And
that's
after that,
perfectly
it's just
reasonable.
30 seconds.
I think that's perfectly reasonable. I absolutely do. Yep. Yeah, because people can hijack your meeting otherwise, and you can't get done public business otherwise. So absolutely, I think that's reasonable. Okay, so as I told you, the board can only act as a corporate body. You can delegate your ministerial duties, the things that anybody could do is essentially it. You cannot delegate, as I told you before, anything that's statutorily assigned to you or anything that's discretionary. So for instance, there's a proposal. Your superintendent could not go out and establish a school outside of your school boundaries, okay, because that's discretionary. A school district does not necessarily have to do that. So your superintendent could not do that alone. That is something that would have to come back to you. Your responsibilities by statute are that you are the owner of the real and personal property. You acquire it, you hold it, you sell it, you donate it, you dispose of it. You are the folks who sue and are sued. So when lawsuits are filed, they're filed against you. You accept donations and the limitations on those donations and decide whether or not you're willing to accept those limitations. You govern and oversee management. Your duties that are not delegated to TEA or State Board of Education are yours. You adopt policies. You have the ability to request assistance from the Attorney General in a number of matters. His guidance, his assistance in certain kinds of lawsuits, and his assistance in certain kinds of complaints. Your responsibility is to make sure employees follow the laws and regulations. And the way you do that is by establishing policies. That's how you make that happen, is because you require your employees to follow those policies. So you establish the policies, and then it's up to the superintendent to enforce those policies. And according to your local policy, BI local, the superintendent then is to report compliance to you. According to your BI local, your superintendent is also supposed to give you periodic reports and performance metrics so that you do know what is going on. According to your BI local, your superintendent is also supposed to provide you structured workshops on management systems occasionally. I suspect this is one of those things. You are required to submit information requests Monday before a workshop, and then you receive the information 72 hours before a meeting. And you do have a very efficient system for doing those kinds of things, for asking for information. Some of the things that are your mandatory board responsibility is establishing, by law, establishing working relationships with public entities to serve students. So if you're going to work with JJAEP, for instance, if you are going with the county to establish a JJAEP, if you're going to work with United Way, if you're going to work with outside agencies, outside entities, the city, you will do so through contracts. You are to adopt the vision statement and goals and to monitor progress on those. You establish performance goals, and you provide oversight on student achievement. You are also supposed to ensure that the superintendent is accountable for results. You collaborate with the superintendent. You adopt district and campus level decision-making processes, which you've done by policy, and you publish an annual performance report that is made public. You also adopt an annual budget. You adopt a tax rate. You monitor the district finances, which you do every month. You ensure that an annual audit is conducted, and you publish an annual financial report. You conduct elections, you call elections, and you canvass elections. You establish complaint policies for employees, students, and the public to be heard by administration and the board, and we're going to talk about this later. But there was a new statute that says that members of the public have the right to be heard by administration and the board. So your policy GF is going to change as a result of that, because previously it was just open forum for them. Yes,
Quick
sir.
question. When you said there's a new law, are you saying new since some of these operating procedures were created, or new in the last session?
Okay.
What is it?
Everything else I've talked to you about that's a new law is this last legislative session. This one was, I want to say, not this legislative session, but the one prior to that, was when they established a new set of mandatory board responsibility and discretionary board responsibility. I want to say it was then, so it hasn't been that long ago. You terminate non-renew employment of Chapter 21 contract employees, and you've got a procedure for that. We'll talk about that. You adopt employment policies. Superintendent has the sole authority to recommend personnel. In this case, he has a sole authority to hire personnel because you've delegated that to him. Principals still get to approve campus assignments, and you have to post vacancies. Now, what that means typically is that the superintendent has the authority to assign and reassign employees. And so what the superintendent will do when you get a vacancy is he may decide that there is a person who would be great for that job, and he can plug someone into that position. And he can do all kinds of shuffling around of employees. But at the end, there's still going to be a vacancy, okay? That's the position that you post, is whatever that last vacancy is. Or he may decide that he's not going to fill whatever position after he's done this shuffling, and then you don't post. So it is, it's not, except for superintendent, when it's superintendent, you have to post that vacancy. But for everybody else, the superintendent first gets to assign and reassign, and then he posts whatever is left. You must be the one to hire the superintendent. You must be the one to evaluate the superintendent, and you must be the one to restrict written reports from staff. The way you've done that is you've established policies that do that. You adopt the budget. You seek accreditation, and you maintain accreditation. You accept or deny Peg grants. You don't see many of those anymore, and student transfers. You adopt the student code of conduct. That's your responsibility. You are to meet with the juvenile county board. You notified juvenile courts about DAP assignments and expulsions. Superintendent has that responsibility also. So we tend to let him do that and copy you on those. And then you, of course, must follow all applicable laws and regulations. You do have discretionary duty, things you don't have to do, but you can choose to do, such as issue bonds and levy interest and sinking taxes. You can call for a bond election. That is your option to do so. You do not have to do so, but that is very discretionary with you, but it is something that you must do if you're going to do it. Levy M&S taxes, same thing. You will establish a tax rate every year. But what that tax rate is completely discretionary with you. You can employ a tax assessor collector, or you can work with someone who will do that responsibility for you. You can require certain employees of the district to come and meet with you and talk to you. Your business and curriculum directors, you can require that they come, whether the superintendent wants them to be here or not. It is within your discretion to require them to be here to talk to you. You can enter into contracts, or you can delegate that to the superintendent. We already talked about the others, except for contract for educational services. You can contract with outside entities to provide educational services within the district. And you have done that on a number of occasions. You can charge fees. There are limits on the fees that you can charge by statute and what kinds of fees you can charge, but you can choose to do that. You can change the district name. I don't recommend it, but you can. And you can require school uniforms. You can hold classes at other institutions of higher education as opposed to on your own campuses. You can create schools, or you can have programs outside of your school boundaries. That was a big deal with the Attorney General a few years ago. So when this statute came in, they resolved that issue, that you can operate schools and operate programs outside of your boundaries. You can set up before and after school programs if you think that's appropriate for your students to have. Okay, next scenario. Do y'all need a break? How are we doing? You need a break? Okay, let's take a quick break. Don't talk about public business. That's all I ask.
want to be at the workshop, violating topic of the workshop. So trustees, we have an option to, because we plan on ending at 8, we can end at 8, or we can begin the next session at once you want to cover, which will probably take, how long roughly?
Let me see what's next. Oh, I'm not, let's see.
I don't think so. Did we get to the end of what we were expected to do tonight, Chief Lair?
We're close to it. What slide is it, Lynn?
What slide are we on? We're on slide 79. We would have, plan was to get to about 120, but we started late and we're kind of taking time,
Trustee
so that's not a
Mitchke.
problem.
Mr. President, given the fact that we just have the bare minimum number of trustees here, and the purpose of the workshop is actually to educate everybody, it doesn't seem like, we really have the incentive to cover the material with just us 5. We're probably better off trying to cover those 40 pages or so that you've just referenced with a larger group. And I would just repeat the request that I made earlier, though, about giving examples between the difference between governance and management, because a lot of people think they're synonyms.
Sure,
And
they're not.
And a lot of the discussion that we have in all the TASB materials, even in our own board operating procedures, it's abstract. But what we really need are examples of parent comes to you and complains, teacher does something wrong, trustee doesn't like principal, and what you're supposed to do with those very specific examples. Because going back through the abstract summaries that everybody does,
Okay.
that's part of every basic training, TASB's training looks exactly like this. It doesn't really help somebody, particularly somebody who's not a lawyer, to actually know what they're supposed to do when the fact situation actually arises.
Okay, I can do that. I can definitely do that.
So can I, may? So following up on that, so Board President Board President Henry, since I can't talk to former President Mitchke. So what you're saying is that you basically want like a cheat sheet, like a FAQs, like written scenario management, governance, the do's and don'ts.
As President Henry, since I cannot directly respond to
disagreements.
former President Flores,
Disagreements.
I would say,
Is
yes,
that
we
to
would
the-
like sort of the Gilbert's version of this.
Okay.
Thank you.
And it's that you spoke really well when you said to avoid having people believe that your role is simply to fix our problems the way that people want. So I think as elected officials, it's hard to then distinguish, these are things that you have come to me that aren't within my role to
Right.
accomplish. And I think that's exactly what those very specific examples will accomplish and show. Not only am I one of 9, but it is not my job to handle that specific principal at that school that you're unsatisfied with, or those
Okay.
things. So
Okay, I can do that.
something like that would be just helpful to show beyond.
Okay. Mhm. Okay. Right. Mhm. Okay, I can do that. Okay, so,
So what I'm hearing is we'll reconvene, hopefully with more members of our board, and continue the presentation, and you'll be working on a list or a spreadsheet or a cheat sheet of the distinction with real-life examples, governance and not governance, and then also the role of the board, what we are and not able to do.
okay.
A parent emails me and says, she doesn't like the principal, what I can and can't do in that situation.
Okay, all right, so we come back Monday, and my schedule is pretty booked between now and then. I know we come back on the 28th also, so I'd like to promise you the cheat sheet by the 28th as opposed to Monday, if that's okay. What I will do before Monday is I'm going to go through and put a whole lot more examples in here, because I think the examples then give us that ability to talk about those things. Will that work for you okay, if I do it that way? So that we have more
Okay.
examples to talk about starting Monday.
Okay. And I'm hearing from Chief Lear, because I'm not going to do the administrative aspect of this role, that she's suggesting that maybe our legal team as well could work on some of those examples.
Oh, great, that's a great idea. That's
Does
excellent.
that work for you, Dan, and Trustee Flores? Okay.
That's excellent.
Okay, that sounds good.
Great, okay, we have a plan.
Well, thank you for your time.
Thank
So this was very helpful. I can only speak for myself as a trustee. So thank you for taking the time to prepare
Thank
this and present it to us today.
Thank you, I appreciate it, and I'll see you Monday. And what,
The time is now 7:59 and this meeting is adjourned.